Good afternoon, and welcome everyone to the second meeting of the Senate Select Committee on Health and Wellness. Madam Secretary, please proceed to call the roll.
Senator Buck. Senator Cruz Crawford. Here. Senator Lang. Here. Senator Stone. Here. Senator Taylor. Chair Doniate.
And I'm here, and thank you so much. We have reached a quorum. Welcome everyone to the members of the audience in Carson City and Las Vegas and those who are following our meeting online. Today we only have one bill hearing that has been referred to us, which is for Senate Bill 7. Before I begin, I want to make a few housekeeping announcements. First, I would like to remind everyone to please silence all electronic devices while you are here in the committee room. Members of the public may provide written testimony in different ways, including all of which are listed on the agenda. Today we will have public comment towards the end of the meeting, and you may also submit public comment in writing either in addition to testifying or in lieu of thereof. If you wish to testify in person, you can sign in at the table by the door and leave a business card with the committee secretary. And when testifying in person, please turn the microphones on to speak and off to listen, as we have others listening to and viewing the meeting in Las Vegas and online. Anyone who would like to receive an electronic notifications of scheduled bills and access to the committee's meeting materials, we can do so by signing up on Nellis. And committee members will be using their laptops to view handouts and other exhibits, so please do not view this as a sign of disrespect and inattention. With that, we'll start with the hearing on Senate Bill 7, so I'll go ahead and open up the hearing. This measure revises provisions relating to occupational diseases, and I will go ahead and invite our co-presenters to begin when they're ready.
For the record, Ryan Beeman, representing the firefighters in Nevada, professional firefighters. Thank you for hearing this bill, Senate Bill 7. I think a copy might be being provided right now. I know there's not one up online, but I'll try to do my best to walk it through if there's a question. I think it's now being provided. Okay, you have it now. Okay. For the record, as I said, my name is Ryan Beeman, representing the professional firefighters in Nevada. I'm here today to testify in support of the bill to clarify and restore the conclusive presumption for lung disease, NRS 617455. Just a little bit quick background on this legislation. In 1965, the legislature enacted the lung disease statute with a causation-based standard that you had to prove that the lung disease resulted from an exposure to heat, smoke, fumes, tear gases, or other noxious gases. That section remains today in subsection 1. In 1989, through AB 755, the legislature made a deliberate policy shift, recognizing the difficulty of proving causation for both heart and lung claims. Lawmakers adopted a conclusive presumption for professional firefighters, arson investigators, and police officers after 2 years of continuous, uninterrupted salary service. This created two distinctive mechanisms: exposure-based claims under subsection 1, which remain available to volunteers and others, and 2, the conclusive presumption claim under subsection 5, based solely on years of qualifying service for professional firefighters. The Nevada Supreme Court confirmed this reading for heart disease in the Manuel versus County in 2007, holding that the conclusive presumption operations independently of causation and applies even to congenital or pre-existing heart conditions. That is exactly how the 1989 legislature intended for the presumption to function. The problem is that this past week, there's been two decisions. One that was a Las Vegas Metropolitan and Watterson case, and then also a Supreme Court case that just happened a few days ago with the city of Henderson, and has upended this settled understanding. Both courts held that the lung conclusive presumption in subsection 5 is not independent, and that the claims must still prove exposure under subsection 1. The interpretation collapses the conclusive presumption in existence and reverses decades of consistent practice and undermines the legislature's clear intent dating back to 1989. The result is immediate disruption. Lung disease claims for professional firefighters, police officers, and arson investigators will now be denied unless they can prove a specific exposure, which is impossible burden in many of these cases. This doesn't only affect active employees, our current retirees who served decades under the belief that their lungs were protected just like their hearts now face uncertainty. Many of them are already battling chronic lung conditions for years. Their families relied on conclusive presumptive for security in their retirement. The promise Nevada made in 1989 after the 2 years of continuous service lung disease would be conclusively presumed for job-related. The decision creates an unjust disparity. Heart disease claims retain the conclusive presumption, but lung claims are gutted. The law now treats the heart as worth of protection, but the lungs, even though both are equal, vital and survival, and equal to endangered in this line of duty. The bill makes the narrowest statutory change necessary to restore the legislative intent, aligns the lung conclusive presumptive language in NRS 617-455, subsection 5, with the heart conclusive presumption in NRS 617-457, 1A. This also ensures that the lung presumption functions exactly the same way the heart presumption does under the Manuel case. Preserves volunteer firefighters' protection under subsection 1 and maintaining their ability to bring exposure-based claims. It also clarifies retroactivity applying to all open, pending, and active claims, because we want to make sure the retroactivity is in there, because we currently have individuals that are either going through medical investigation currently, or they're in the denied process of the hearings levels, appeals level, or district court, and we don't want them to be in this donut hole. If the language does go back to the way it was for the last 35 years, that those claims will be processed just like we've been doing for the last 35 years. So that's what the retroactivity means, and there's no new impact to local governments cost-wise. In closing, this is the expansion of benefits. It's not an expansion of benefits. It's restoring the legislative intent that was in there since 1989, and that providing causation for heart and lung disease was impossible and gave our protections for the conclusive presumption. The bill corrects the misinterpretation with the smallest statutory change possible. It preserves rights for volunteer firefighters and restores fairness for police firefighters, and reaffirms Nevada's promise to us that we be protected. I stand for any questions, but I know I have two other co-presenters that will be very quick.
Good afternoon, Mr. Chairman. For the record, Danny Thompson. I'm today representing myself. Just want to tell you give you a little history. 1989, I was the chairman of the Government Affairs Committee in the Assembly. I was in my 5th term in the Assembly. I was also the vice chairman of the Labor Committee, which I had been for 10 years. And at that time, the workers' comp system in Nevada was a state industrial insurance system, which was a state agency with state employees running it. And over the years, as a legislator, I had constituents come to me and say, we've got this law, but I filed my case. I obviously have lung cancer, and they deny my claim. And so as the years went on, and I heard this story repeatedly from constituents that, and you know, we had the Council Bureau check, and the reality was that local government was denying every single case and then making every single person fight for the benefit that was in the law. That was, I thought, was pretty clear. And so I went to Kim Morgan, who at the time was in the legal division. She wasn't the director. She was a lawyer there. And I said, what is the strongest standard that I can put in a bill to say that I really, really, really mean this? And she said, well, that's a conclusive presumption. If it's conclusively presumed that your problem is a result of your job, then that's the strongest language and the strongest standard that can be put in the law. And so I got a bill. That change was my change when I was here. I introduced the bill, and I explained it to the legislators that were here at the time in the exact same way I explained it to you. And the Council Bureau told them that the strongest possible standard to say you really mean this is that's it. And understand, at the time, it was the State Industrial Insurance Commission that was run by the state with state employees. Now these are all private insurance companies, and who knows who they are. And so throwing that standard out is really just gutting the whole thing, because you're going to go back to, because I can tell you today, I don't have statistics, but I'm sure they can tell you, every case gets challenged the same way. And without that protection, When you have a real problem, you're going to have to go to court. You're going to have to go through the process. But at least you have something that says the legislature really, really, really means this, that they're covered. And so I think it's important that you correct this problem that was created by this decision and restore the benefits to those police and firefighters who take care of everybody every day. Thank you.
Good afternoon, Chair, committee members. My name is Todd Inglesby. I'm the president of the Professional Firefighters Nevada. I just want to take time to thank you for hearing this important issue. This important issue is not about just getting our members back to work in a timely manner so they can serve the citizens that you all represent, but it's a matter of sometimes can be life and death. We've had people come here and testify because their claims were denied. They were unable to get the treatment that they deserved and their conditions worsened, and to the point where we have had people come and testify in the past that because of the delay, they can't get any help. And they're basically doomed to death. That's what we're talking about. It's about getting our members back to work in a timely manner, not having us go through this legal battle, which we already do and do currently. But without that language, every single case will be just like Mr. Thompson said, will be denied, and we'll have to go through that process. People not only be able to go back to work, but we will lose people in that process too, because they'll be unable to get the treatment that they need and deserve to not only live a normal life, but and do their job, but it will die. Thank you.
Thank you so much. Committee members, do we have any questions? Our Vice Chair.
Good morning, afternoon. We lose track. So I just wanted to clarify one thing that I think I heard you say, Ryan. Because of the break in coverage, because of the ruling, now there's a break in coverage. Are those people that are in that gap going to be covered? Are they, when we pass this, and I'm sure we will, I just want to make sure that they're going to be able to continue with where they were and they aren't going to lose out on benefits because there was a break in coverage. And if we need to put something in there to make sure that it says that.
For the record, Ryan Beeman, representing the firefighters in Nevada, through the chair to Senator Lang. Yes, and that's what was trying to explain in the retroactivity of the bill, is just to make sure that we put that language in there to cover the individuals that are currently in that process. Because some of them are going through the medical investigation, hasn't been accepted or denial, because sometimes they're collecting information to determine if they're going to accept the claim or not. We have people that are at the first step of the appeals of denial, which is a hearings officer. We also have the next step, which is the appeals level. We have a group of people that are at that. And then district court. We want to make sure that the retroactivity is that if you, hopefully you do pass the bill, that those individuals were not left in like a donut hole where the local governments or the employers could say, sorry, yeah, that new law went into effect, but you're in this donut hole because the 3-day ruling, you guys are have no coverage. So that's what the retroactivity is.
Okay, thank you. I just want to make sure I got that on the record. If it were ever questioned, that we are everyone has an understanding of exactly how the process will work.
Thank you, Senator Taylor.
Thank you, Chair. And thank you, gentlemen, for being here. I want to, I've taken a lot of notes on this, and this is great. I just want to make sure I have the, have my arms around the whole piece of it. What happens now is that because of former legislation and so on that you were a part of enacting, Mr. Thompson, really, if after a couple of years of treatment, it's presumed that really that injury, we know heart and lung, but we're talking about lung, right, is connected to something that happened on the job. That's the way we have it currently. And you don't have to necessarily prove that because it's presumptive. It's presumed that that's the case. And what we're talking about with this legislation is keeping it that way because of the recent decision would say, well, actually, you have to prove that it's because you're on the job and you breathe in this smoke and yada, 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 yada. And this is to prevent that couple other things of volunteer firefighters and so on. But this is to say, no, let's go back to that, because that's next to impossible to prove that on this job, at this site, fighting this fire at this time, this fire, I just want to make sure I have my arms around that and my understanding of this.
For the record, Ryan Beeman, representing the Professional Firefighters of Nevada, through you, Chair, to Senator Taylor. Yes, I mean, and that's what we want to make sure that we fix the language to go back to the way it was 35 years ago. That was just changed 3 days ago. Being on the job, I'm in my 30th year of the fire department. I've been on numerous exposures, something that we haven't been tracking. I can't say if I came down with a lung disease that I could go, that was that one incident. I've been on numerous incidents over my career. And the other part of it is also we currently have retirees who also have this benefit, that they are already retired. They don't have any type of because they haven't been documenting, oh, I had that one fire there as my documentation of my exposure. So this also helps them.
And I'd just like to add one thing. Todd Inglesby, President of the Professional Fires of Nevada. This also protects men and women who we didn't have the health precautions and the safety equipment that we had. It changes weekly, it changes monthly, it changes year over year. We sent people back in the day into fires with no breathing apparatus. Now we have breathing apparatus. We've done everything we can to prevent ourselves from getting these things. However, now there's more carcinogens in things that are built versus what they were years ago. So it's a give and trade for those things too as well. And this doesn't change the current process that we've been doing for 35 years on either side. Thank you.
I appreciate that. Thank you, gentlemen, and thank you for your service on the front line. Chair, thank you so much.
Mr. Chairman, can I make one point? So in my professional life now, I have a client who is involved in the PFAS settlement. PFAS are forever chemicals that you all have heard about. And the case has been settled, and now they're awarding benefits to people who are exposed. Firefighters, the equipment that they use, the clothes that they wear have PFAS in them. So every time they put on a pair of turnouts, every time they squirt foam on a fire, that's PFAS. Now, I think they just recently took the PFAS out of foam. I don't know if they did or not, but all of that stuff is still there. And so to say that I have to prove, I mean, it's pretty evident. Otherwise, that case wouldn't have been settled.
Thank you. Any other questions? All right, let's go ahead and begin testimony and support. If you would like to come and support, please come forward. And we'll start here in Carson City. You may begin.
Good afternoon, Chair, members of the committee. My name is Harrison Porter, Harrisonporter. I'm the Vice Chairman of the Las Vegas Police Managers and Supervisors Association. We represent the sergeants, lieutenants, and captains of LVMPD. I'm also representing the Public Safety Alliance of Nevada, a coalition made up of law enforcement from the state of Nevada. This bill strengthens an essential protection for Nevada first responders by ensuring that the conclusive presumption for lung disease truly reflects the realities of the service. Police officers encounter a wide range of airborne hazards during tactical operations, crowd control incidents, and meth lab responses and emergency calls. In many cases, it's simply impossible to isolate a single exposure, especially years later after a symptom develops. Yet the occupational risk is undeniable. Our first responders have never conditioned their willingness to act on whether the air they breathe is safe. They step into unknown and dangerous environments every day to protect our communities. This bill simply ensures that the state honors its commitment to them when the long-term consequences of that service take a toll. Thank you, and I urge your support on this bill.
Hi, Shelley Capurro, representing the Nevada Police Union, and we support this bill. Thank you so much.
Thank you. Anyone else? Let's go to Las Vegas, please.
Hello, Chair, members of the committee. Jason Mills on behalf of the Nevada Justice Association. We are in support of SB 7. Just briefly, as a little bit of background, the presenters got it right on the head. I just wanted you all to understand that the causation language for heat, smoke, fumes, noxious gases has been in place since 1965. And as Mr. Thompson indicated, it was in 1989, after several decades of having difficulty proving up those claims, the Nevada legislature adopted the conclusive presumption for both heart and lung disease, even congenital birth defects, according to the Manuel decision for heart disease claims, which was rendered about 15, 20 years ago. This decision that came out 2-3 days ago stunned not only myself, but the entire community. We cannot fathom how the Supreme Court has now put a causation element by requiring firefighters and police officers to prove an exposure to and for a causation element, and only after they prove that exposure and causation, then they get the conclusive presumption if they have the time on the job. That literally makes no sense and is running contrary to what Mr. Thompson and the legislature did back in 1989. The claims that in the 25 years that I've been doing, it is completely understood that these are conclusive presumptions in the heart and lung capacity. About 2 or 3 years ago, we started to see this novel defense started to rear its head that no, for lung claims, you need to run through the causation element to get to the presumptive conclusive presumption. I still can't even fathom that reasoning, but apparently the Supreme Court bought it. And they are now put it in a decision that binds literally every single police officer, firefighter, and arson investigator in this state, and every single retiree that has been promised these benefits were now stripped from them from this decision. It was a stunning decision that literally does not make that much sense and is running contrary to exactly what this body did 36 years ago. With regard to the retroactivity, they're absolutely correct. It's not digging up new claims. The reality is there are scores of these cases that are sitting out there right now that will immediately be denied and immediately be upheld with this decision, because you can't really prove the causation to heat, smoke, fumes to a specific event, which is why the bill was amended in 1989. So the heart language is clearer because it didn't have an existing heart rule back then. They only had an existing lung rule. And then in 89, they added heart and lung, and they just plugged in the conclusive presumption into the existing lung statute. Clearly, the intent of the legislature was to develop that conclusive presumption for professional firefighters, arson investigators, and police officers. We entreat your support to this bill. Any questions, I'm happy to address.
Thank you so much. Anyone else in Las Vegas? Let's go to the phone lines. AVH, is there anyone online?
Thank you, Chair. The public line is open and working, and there are no callers at this time.
Thank you so much. Let's go to opposition. And would anyone like to testify in opposition? Please come forward. You may begin.
Thank you, Chair, members of the committee. Warren Hardy, representing the Nevada Urban Consortium. I'm at a bit of a disadvantage here because I just saw this language 20 minutes ago. I'm not an attorney, but I've been involved in this legislation for many years as a member of the Senate, and we have had robust discussions through the years about whether or not to statutorily make this a conclusive presumption as opposed to a rebuttable presumption. It is my understanding that the standard currently, and the standard of the Supreme Court held up 2 days ago, was that of a rebuttable presumption. To indicate that there's a conclusive presumption, the statute, and I'm not an attorney, but the statute doesn't seem to support that. When you speak about heart, it's very specific that you have to tie the injury back to something that occurred on the job. With regard to firefighters, it's very specific that when you start the job, you have to have an examination. That's not a conclusive presumption. That's a presumptive assumption. You've got to prove certain things before the claim can be verified. If you make this change, so even, I will say this, even if we're trying to change the law to say we want to cover firefighters in every case regardless of causation, this language, the way it's drafted, goes beyond that and makes every single claim for heart and lung a conclusive presumption. I haven't read the Supreme Court case. I've heard peripherally about it.
It appears to me that what the Supreme Court did was uphold NRS 617-457 that establishes a clear presumptive rebuttable presumption on heart and does the same thing on lung. This goes well beyond the issue that was addressed. And to try to change this policy, again, I've been working on this for 30 years. And each time it was the question of whether we go, it's either conclusive or presumption. I believe, I'm willing to stand corrected, but I believe the current standard is a rebuttable presumption. So I would caution the committee, this is a sweeping policy change that will cost local governments millions of dollars because it's not limited, as it reads, to firefighters. It's every heart and lung case that comes in industrial insurance. So I would caution the committee to act so quickly on this without fully vetting the issue. Thank you, Chair, for the time.
Thank you, Chair. For the record, my name is Vincent Guthreau. Last name is spelled G-U-T-H-R-E-A-U. First name is Vincent, V-I-N-S-O-N. Yeah, similarly to the previous speaker, we haven't had full time to review. I represent NACO, the Nevada Association of Counties. I'm the executive director, and I'm up here for all counties. There are other counties in the room, but we haven't had an opportunity to review the legislation fully and the impacts. We do need a little bit more time to do that. At first glance, I do think we have some concerns around the retroactivity and that it is outside, I think, and again, in our initial review, to the applicability of the special session proclamation. But again, we will take a look at this. I think we need to assess some of the fiscal impacts. We'll work on that. We'll work on that as soon as possible. If we need to fix it on the other side or in this committee, we will do so. But we do have some initial concerns, and for that we are opposed and wanted to get that on the record. So thank you for the opportunity.
Good afternoon, Chair and members of the committee. Leah Cartwright, Leacartwright, here today on behalf of the American Property Casualty Insurers Association, which does include employers, insurers. I will submit the Supreme Court opinion, Holquin v. City of Henderson, and the justices did opine on the cases mentioned by the bill presenters. The bill here before you would completely negate NRS 617-455 subsection 1, which does require the exposure be caused by heat, smoke, fumes, tear gas, or any other noxious gases, which should cover any of those mentioned before. I know that my colleagues before me had much more eloquent ways to put this, and like they said, we have not had time to read and vet this legislation. There is likely a fiscal impact to the premiums that folks pay on their workers' comp for these, so we will do our due diligence and attempt to get those to you as soon as possible. Thank you.
Good afternoon, Chair, members of the committee. Paul Marek from the Vegas Chamber. Because of the quickness of how quickly the bill was introduced, the Chamber did not have time to talk to the proponents of the bill, and of course also recognizing the Supreme Court dropped this 2 days ago, which we understand does cause folks to have to move quickly on these issues. The courts have been busy. So on that very quickly though, the Chamber from first glance is concerned because the end cost is typically passed on to the business community as some of the largest taxpayers, and from that perspective, and so that is where our concern right now is. Of course, we do believe that employees should have coverage and so forth, but this may go further than intended. It may have additional costs that would be paid on to taxpayers, which of course the business community is one of the largest in local and state governments. Thank you so much.
Thank you, Mr. Chair, committee members. Misty Grimmer representing Employers Insurance Company. We are currently not in the business of representing heart-lung, but similar to what other, to covering heart-lung, but similar to what other people have testified, work comp is super complicated. This issue in particular is super complicated, and so we would appreciate more time to work on something like this before legislation is passed. Employers is in the business of reinsurance, which is one of the things that, because claims have gotten so expensive, local governments have to go out and try to seek reinsurance coverage. And so we are in the business from that perspective of these types of claims, but similar to what other people have said, we really need more time to understand how this could affect the policies, could affect the market. So this is quite a surprise, but so for now we're in opposition. Thanks.
Thank you. Anyone else? Anyone in Las Vegas? AVH, is there anyone online?
Thank you, Chair. We have no callers at this time.
Thank you so much. Anyone that would like to testify in neutral here in Carson City? In Las Vegas? AVH, is there anyone online?
Chair, there are no callers on the line at this time.
Thank you so much. Any closing remarks?
For the record, Ryan Beeman, representing the professional firefighters. I'll just be real quick. Mr. Hardy, I have total respect for. I've worked with him for numerous years on this issue. But I know he said he didn't have time to read the bill, but I just wanted to clarify that in subsection 5, it already states that there's a conclusive presumption. There's never been a rebuttable presumption in subsection 5 outlines that there is a conclusive presumption in the law. And as I said before, this has no effect on cost to the local governments. We're not changing anything except changing back to the way it was for the last 35 years by the decision of the court the last 3 days. So local governments would continue to cover as they have done for the last 35 years.
Todd Inglesby, representing the professional firefighters of Nevada. This also doesn't change the current process that the employer and the employee have to remedy this situation too as well. Does not affect any of that. Does not change the current appeal process that we have, the hearing process, or anything that we currently do too as well. Thank you.
Thank you so much. With that, we'll go ahead and close the hearing. All right, we have a motion. We're gonna have a motion from our Vice Chair Lang.
Thank you, Chair. I move that we do pass Senate Bill 7.
I'll second.
Thank you. I have a motion from Vice Chair Lang and a second from Senator Cruz Crawford. Do we have any discussion on this bill? Seeing none, all those in favor, please say aye. Aye. Any opposed? No opposition. Motion carries, and we will give that floor statement to Senator Canizaro. With that, we are now at the last agenda item of today, which is public comment. Is there anyone that would like to provide public comment at this time? Seeing none here or in Las Vegas, AVH, is there anyone online?
Thank you, Chair. The public line is open and working, and there are no callers at this time.
Thank you so much. That concludes the work of today's agenda, and we are now adjourned. Thank you so much.